that some may think a little yawn, or some may think, oh my gosh, I have no idea what this IP is. And that's exactly what this session is for. Our speakers today will be essentially breaking it down for you in a way, in a way that is very easily digestible, and you can leave this session feeling like you better understand the topic. Okay, so I'd like to go ahead and quickly introduce our speakers for today. First, we have Ms. Kherk Ying, Head of IP and Dispute Resolution for Wong and Partners. Over there, we have Mr. Gerald Samuels, Trademark and Design Agent for Messrs. Gerald Samuels. And last but not least, we have Ms. Camilla Anastasia Alim, Legal Specialist for Maxis Communications. I'll go ahead and pass my microphone so that way you can get started. Please enjoy.
Thanks. I guess with a time constraint, what we thought we would do is we will give a quick introduction to each of the types of IP that's protected in Malaysia, and we'll probably give some fun facts to, to make it a little more interesting, and then we will do typical misconceptions that people have about each of these IP rights. So with that, let me start. Yeah. So what is intellectual property? This is the shortest, simplest version that I can find, and this is from WIPO, which is IP is really the creative product of the mind, and is exclusive right to use by the developer, may be legally protectable. What I mean is that if you have a creative, you have a creativity that is then reduced to any form of permanence, that is the IP. That means everything that is intellectual property actually comes from the creativity of a person. And when that is then translated into something, that something is the one that's usually protected by IP laws. So what are types of protected IP? Typically, we have copyright, trademark, patents, industrial design, confidential information. There's some others like geographical indications and integrated circuits, which is, I think, less often, I think, in touch with by most companies. So we will focus on the 5. Hopefully by the end of today, or this session, you have a clear idea what each of these rights are. So let me start with copyright, okay? We just had a quick discussion, and we said that most people that are not involved in as much with IP usually say, I like to copyright that, I like to copyright this. So actually copyright is actually a very special right. Let me just run through the typical features of copyright. The copyright is actually as what we call a statutory right. That means your right comes from the act called Copyright Act. It essentially protects an expression of an idea where it's translated in any form of permanence or recorded form. There is no compulsory registration of copyright. The registration for copyright is actually voluntary. Okay, this means that you don't typically see a copyright certificate of registration. You see that for patents, you see that for designs, you see that for trademarks, but you don't typically see that for copyright, because registration is only voluntary. Even if you do not register copyright, your copyright is still protected under law. So that's important. Yeah, protection is typically life of the author plus 50 years. We have some type of rights, what we call more commercial rights, like sound recordings, broadcasts, published edition. These are just 50 years from first publication. But literary work, artistic work, musical work, these are usually protected for life of the author plus 50 years. And the other two a feature of copyright which I thought I would mention is in terms of ownership. If you're an employee working for an employer, your employee who creates, let's say, the software or the design, the copyright in that work belongs to the employer, barring any agreement otherwise. Person paying as well, if you commission an artist to draw a painting of yourself and you pay for it, you own the copyright and not the painter, though the painter is the one who created the works for you. So we have some exceptions that is should be quite interesting to be aware of. Now moving forward, so examples of protected copyright, this is kind of fixed. The types of rights protected under copyright is fixed. So it's literary works, musical works, artistic work, films, broadcasts, sound recordings, and some what we call derivative works like translation, that means adapted from an original work, collections, compilations. So all these are protected by copyright. Now moving to quickly some fun facts. I'm not sure whether you're aware. If you recall, I said that copyright protection is normally life of the author plus 50 years. So for example, do you remember when Walt Disney passed away? It is 1966. Who knows? Next year, 2016, make sure it's way after, check the exact date of death, yeah? All of us could be probably making Mickey Mouse cakes and Mickey Mouse books, but be careful because Walt Disney actually have trademarked quite a lot of these cartoons as trademark as well. So you need to be careful that, you know, sometimes works are protected by both copyright and trademark, and sometimes other IP rights as well. So that's interesting to note. Elvis Presley passed away in 1977. His works will be in public domain after 2027, so all of us can make compilations and some recordings of Elvis Presley songs after that, yeah? Okay. Another fun fact, Barbie doll. You'll be surprised in the US, the face of Barbie doll is protected by copyright. Not considered too common. Another fun fact, this is quite interesting. Cute photo, isn't it? Yeah. And this is actually a selfie taken by a monkey. Okay, so this maybe it's a gorilla, I'm not sure. Can't really see whether it's a gorilla or a monkey, yeah? But basically, he took a selfie himself. Question is, who owns the copyright in the US? It was held that it could not be. But in Malaysia, the decision could be quite different, because in Malaysia, under our Copyright Act, the ownership of, or the author of a photograph is the person that makes arrangement for that photograph to be taken. That is our definition of the author. Therefore, if I cause the monkey to take a selfie, I could be the one said that I make the arrangement for the photograph to be taken. Therefore, I am the author and not the monkey. So I think it would have been a very interesting case for us here if it's decided in Malaysia. So start getting your pets to take selfies, yeah? Okay, another fun fact. You may recognize the tattoo on the face of this actor, and that is of course the famous tattoo of Mike Tyson. The tattooist actually sued Warner Brothers for using that tattoo on the face of the actor, and he was settled for quite a bit of money. Yeah. Now, common misconceptions now. Okay, copyright can protect my ideas? No, I think I've said that. While the idea is in your head, is not protected, sorry. You must have drawn it down. If you're whistling a tune as you're walking out in a day, that tune, until it's written down in musical notes, is not protected by copyright. It must be reduced in some form of a permanent form. I can copyright my name and title. No, generally names are not protected as copyright. Yeah, names probably you need to look at trademark. All right, so sorry, all your names not so special to be copyrighted. Now, if it's unpublished, copyright doesn't apply. Not true. As I said, copyright protects the work automatically. You don't need to register. So the moment I finish this, for example, these slides, copyright subsists immediately. Okay, whether it's published or not published, is still protected. Okay. I can copy anything from the internet. This is, I think, the most typical misconception. No. Okay, every content on the internet is protected by copyright. It's only a question of whether there's fair dealing. That means whatever you have taken is fair. Maybe you have a fair dealing defense, or it's for personal use as also a defense. It's only a question of whether you can find a defense. But it is not everything there is protected by copyright, or it could be in the public domain. That means expired. You know, like I say, old literature books. That is written in the 1880s. Sure. You know, you can still print it, and you can still make copies of those. Last misconception is that no copyright notice is not protected by copyright. No, it's also not a requirement that you must have a copyright notice. You know, sometimes we have clients coming to us and say that, hey, can you please make sure my copyright notice looks really, really good? Actually, that's not a legal requirement. Whether it's there or it's not there, your work is protected by copyright. Of course, it is there because in some treaties overseas, right, you need to put a copyright notice in some international treaties, but we are not party. Malaysia is not party to those treaties. So there's no legal requirement to put the copyright notice. But it's also just good to know who owns the copyright. Yeah. With that, let me pass over to my fellow panelist, Camilla, to touch on trademarks.
Okay, good morning everyone. So trademarks, everyone I'm sure you've all seen some of these marks walking the streets, looking into magazines and everything. These are all trademarks. They are all registered trademarks in Malaysia and also overseas where they are present. Now, trademark, what is a trademark? It's basically something that will be etched in your mind if you see it. So legal definitions aside, a trademark is something where it's easily recognizable and it is a source identifier of someone's product or services. And some people use it interchangeably as a brand. But the brand is basically more of a perception that is created in your mind, which tells you this is something that's good or something that's bad. But more often than not, people actually use the words trademark and brand interchangeably. And it's quite common, that happens everywhere. So trademarks also, it's a statutory protection, and trademarks are regulated in Malaysia under the Trademarks Act. So in Malaysia, there are basically two kinds of, I'd say, examples of trademarks. You've got traditional trademarks and non-traditional trademarks. So what exactly are traditional trademarks? These can be anything from your words, your signatures, it can even be slogans, letters, geometric shapes, designs. Some of the very common ones that you see out there, I've just given some examples up here. You've got Milo, Calvin Klein, Levi's, Chanel. Of course, some people pronounce it Channel, but you know, we know it's Chanel. You've also got the, other kinds of word and number marks. You've got 7-Up, IBM, MTV. There are the other examples which are slogans. Of course, the ones which everyone can remember, Just Do It. You've also got others which are not up here. For example, the Pringles slogan, once you pop, you can't stop. It's very common, everybody knows it. So these are trademarks which, you know, it's there. And it's not just a trademark, but you remember it also as a brand. For example, if you look at the Volvo trademark, the minute someone says Volvo, you'll remember Volvo for life. It's one of those things that's always going to be in your mind. It's perception that's already created. So moving on, you've also got others. I've got a lot of examples here. You've got devices and logos. You've also got a combination of all of it, where you've got a word, you've also got a device. In trademark sense, it's called a composite mark. So you've got a few elements. For example, if you look at the Milo mark up here, Nestle is a registered trademark on its own. Milo is also a registered trademark on its own. And then you've got a combination of both of that, and that's what we call a composite mark. Then you've got the non-traditional trademarks in Malaysia. Now, non-traditional trademarks include also a host of things. You've got three-dimensional marks, for example, the ones that you see here. Although they're a little bit more difficult to get registration in Malaysia, we do have some non-traditional trademarks in terms of 3D marks that are registered. All these you see up here are either registered or accepted for registration. Then you've got also sound marks. You've got the Looney Tunes sound, I'm sure. Okay. There. I'm sure everyone's familiar with this tune. I grew up on this tune. I know it by heart. Actually, I think even back then there was, I think, a bit of words to it. You've got other sound marks as well. For example, the MGM lion. In Malaysia, it is actually a registered trade. The raw, because it's MGM, when you hear it with that device, yes, it's not just on its own, but in America, it's actually registered. So the raw is registered. Just to give you a little bit of background, I believe at one point there was a bit of a trademark tussle between Harley-Davidson and Kawasaki. They were trying to trademark the roar of the engine or the rattle of the engine, and I think Kawasaki didn't get it through. If I'm not mistaken, Harley also didn't, or did Harley?
In some countries.
Yeah, Harley got it in some countries, but Kawasaki was not very successful when it came to registering their trademark. So you've also got the Nokia ringtone, that's also very famous, the original Nokia ringtone. Let's move on. This is what you call a moving mark. In Malaysia, Windows does not have the flying window. I think you call it the flying window, the moving window registered, but in other countries it is registered.
Can you use your voice now? Your picture and voice?
You, well, it depends if you're famous enough, and I think in this country... Well, we'll move on. The alternative is to use a series of marks in Malaysia. Nokia, what they did was they had the handshake. They put it in different captions, and they had actually registered that. So some of it has been quite successful. You've got these kind of moving marks, but in Malaysia, I believe this has not been registered yet. There are also color marks and smell marks. Now, in some countries, you'll be surprised they've actually registered smell marks. If some of you remember, growing up as kids, you had scratch and sniff items. Today, some of the scents have already been registered. Although these are not in Malaysia, but in other countries you have under the WIPO registration. Also, color marks. In UK, orange is registered. For purposes of Malaysia, and if I'm not mistaken, in MIPO, BP actually managed to secure acceptance for the Pantone green, that is the BP color. So it identifies and distinguishes certain brands. You just need that color to recognize, what that brand is. So some fun facts about trademarks now. Everyone's obviously watched one boxing match or another. And if you remember that phrase, let's get ready to rumble, Michael Buffer makes more money with his phrase than he would actually do stepping into a boxing ring and actually throwing a punch. Yes, but it's not his voice actually, it's that tagline, the phrase. No, his face is not registered as a trademark. Yep. So, and he's also made a lot of money actually licensing out that phrase, where it's used in video games and also in some of the commercials. Another fun fact: Beyonce and Jay-Z, they attempted to trademark the name of their baby, Blue Ivy, but this was rejected by the USPTO because there was actually another company that was already using the name, although at that point of applying for registration, they had not applied for it. It was called Blue Ivy Events, and they were wedding planners. And they were not very successful because they actually wanted to come up with a baby range of products. Also, you've got Taylor Swift. She's registered some of her phrases, such as the sick beat, "Cause we never go out of style." I'm not sure if any of you are familiar with her songs. I'm not a fan, so I'm not that in tune with Taylor Swift. You've also got another one of these US songs, rapper, and also you've got David Hester from the reality show Storage Wars. The phrase "yup," from what I've read up, they've actually settled their dispute out of court. Both were trying to lay claim to the phrase "yup." I think it's pronounced "yup" or "yeep" or however they pronounce it over there. They had a bit of a dispute as to how it sounds. You've also got some of the more generic ones today. Have you all heard of onesies? In terms of baby clothing, they've even got twosies. They've got funsies. All these have become a bit generic. Talking about generic, you've also got trademarks which have becoming very generic words today. Kleenex. You don't say "I'm looking for a tissue," you say "I'm looking for Kleenex. So people have actually started using trademarks. It's a very common word these days. Finally, you've also got Paris Hilton. She had a bit of trouble with Hallmark when she actually tried to trademark the catchphrase "that's hot." And it was then also settled out of court. And today, a lot of people are actually trying to trademark a lot of phrases. So the slogans, the catchphrases, these are now becoming very common as trademarks in Malaysia as well as overseas. So now we move on to the common misconceptions of trademark. A trademark refers only to a brand name or logo. That's not true, actually. A trademark, it can be a word, it can be letters, it can be sounds, it can be shapes. Like I mentioned earlier, you've got geometric shapes, you have got designs. If you want to go a little bit more deeper, under the Trademark Act in Malaysia, it actually defines what a mark is. And so there's a whole category of things which is actually listed in the Trademark Act. Filing an application and seeing it appear on the database means your trademark is registered. That is actually not true. Your trademark is only registered upon receipt of the registration certificate from the Malaysian Intellectual Property Corporation. I actually face this every day in my line of work. I have got colleagues who tell me I need to trademark something. I will file the application today. 1 week down the line, I will be asked, so can I have my registration certificate? They don't realize that filing an application and letting it mature to registration is actually a process, as opposed to putting in the application and actually being told it's a registered trademark. So that is something a lot of us actually need to get used to. Once a trademark is obtained, it is applicable worldwide. For trademark purposes, most trademarks are territorial. No trademark is a worldwide protection. For example, this is a little bit different from copyright. Copyright, because of our international treaties, and there is no registration or a database of registration, it is considered protected once you've protected it in Malaysia, automatically in other countries. But insofar as trademark is concerned, if you want to file a trademark in Malaysia, it's not automatically protected in Singapore, or for that matter in the UK or in the US. You will have to file it in the separate trademark registries in these countries, unless you look for something called the international registration under a community trademark, or you also have the WIPO registration under the Madrid Protocol, where you can actually select the countries and then it will actually be considered registered in these countries. Another misconception, trademark registration is valid for as long as I use my mark. Unlike this one, there's a little bit of a difference from copyright. Now, if you remember copyright, it's 50 years after the death of the author. Whereas for trademark purposes, once it's registered, you have a validity period of 10 years. Thereafter, it's renewable for every 10-year period, which means you can renew it in perpetuity. And if you want to continue using it for as long as you've got products and services running, you can continue to renew it. And that means it can go on and on and on. There is no lifespan, for example, after 50 years. You can just continue to renew it every 10 years. And final fact, trademark registration gives the owner the right to prohibit others from using the word in every sense. That's also not true. A trademark is registered in its specific goods or classes of services. For Malaysia, we've got 45 classifications of goods and services. So, for example, Maxis, we are registered in class 38 because it covers telecommunications. But we have got ancillary classes that we would file our trademarks and register and also use it. So you should ask your trademark agent, or if you've got assistance from external counsel, they can tell you what classification your goods or services fall under. So that's for trademarks. I'll now pass the mic over to my colleague.
Thanks, Camilla. I think we moved to industry design before we move to patents, then Gerald will touch on patents. So on industry designs, so we have covered so far copyright, yeah, if you recall, statutory right for creative works, music, literature, software, all are copyright. And we went to brands, trademarks, traditional, non-traditional marks. So let me now move quickly to industry designs. What is industry designs? So these are industry designs. Who was here in this room? Who's here? Who in this room, sorry, was here where the largest mobile phone was around? Wow, I'm sure the young guy there wasn't around. Your father had it, so when you're a little boy, is it? Interesting. So you can see the evolution of industrial design even on one type of on one type of articles like a phone. So generally, industrial designs, if you can just remember the concept, would be it protects the 3D look of an article, the shape, the configuration. It can apply to basically any article that can be processed through an industrial process, and which also must have some form of eye appeal. Yeah. So what is a registrable design? It must be new. You cannot have existing design that's the same. It must have some form of eye appeal and not a design that's dictated by its function or dependent or forms an integral part of another article. Let me explain briefly. For example, these are very simple design, a brown ball or a cylinder or a cone. These are not registrable because it's really too basic and it's probably not new anyway. Yeah. Articles which are dictated solely by function, like the nail, it has to be sharp at the end, it has to have a little head because you need a hammer in. The shape of the nail is dictated solely by its function. So that particular 3D look of that nail would not be protected. Yeah. Integral parts must fit or must match. Examples would be, say, a car. If you just have a car door, the car door must match the rest of the car, isn't it? You can have a door that's round and the rest of the car, it doesn't fit into that car. So the car door in itself may be what we call a must-match article. But the car as a whole is protected as a design. But parts of it may not be because it falls into the exceptions of a must-match or must fit. Another integral part, you see the 3 holes that must fit into the 5 holes into the tires. That part of it would be what we call functional as well. Okay, so examples of registered design, you can see the shoes, a motorcycle, shavers of all sorts. You know, I'm sure we've seen these articles before. Even patents, 2D patents are also registered. Not to forget that. Even look at that. Even interesting contact lens. Anyone wearing that today? 3D and 2D, you can have a combination. 3D plus you have also the 2D, which is the design on the article as well. Yeah. So some quick fun facts for industry design, because it's quite a quick concept to understand. Yeah. Look at this. This is one of the more iconic design, you know, where you squeeze the lemon and then the lemon would drop down from the bottom, you know, at the tip. And the designer who created this design, he had this brilliant idea when he was squeezing lime on a squid. I mean, like most of us who are not creative, we'll just say how wonderful the squid tastes, right? And this guy, when you squeeze the lime on a squid, he can think of a design that looks like that. The Coca-Cola bottle is a 3D design. What is interesting, the fun fact is that the designer of this bottle was looking for something that is, they say cook, like cocoa, cook like cocoa. So he couldn't find a cocoa leaf. So he actually took the cocoa pot. You know the cocoa pot, have you seen the cocoa pot? At least a picture. It has ribs. So the ribs are the ones that inspired the ribs in the Coca-Cola bottle. Yep, interesting fun fact. So common misconception. A design registration protects how a product works. No, that would be a patent. The design merely protects the look, the 3D look. That means you can stop someone else from following your design. But if someone else changed the design, you can't sue. If the change is different, it's no longer similar, then that would be a different design. Okay? My design registration is conclusive. A lot of you will file a design and you get a design registration after about 12 months. Not really. It is what we call prima facie, because any design registration can be attacked on grounds that it is not new, on grounds that it is functional, on grounds that it shouldn't be granted on must fit, must match grounds as well. So it is not conclusive in that sense. Another common misconception, my protection for registered design lasts forever. No, the only right that lasts forever is trademarks, like Camilla said. Every 10 years, if you renew, trademark can last forever. All other IP rights has a shelf life. For designs, 25 years, every 5 years you renew. Design registration international, the same concept as what Camilla said for trademarks. If you file in Malaysia, you only get protection in Malaysia. If you want protection in the US, in Hong Kong, in Singapore, in Thailand, you need to file separate design registration in all these countries. Okay. So last misconception, industrial design only consists of 3D. No, as you can remember, the 2D patents can also be protected by industrial design. Okay, we will take questions at the end of the session. So let me pass the mic to Gerald.
Hello. As far as patents are concerned, it's basically a right which protects the invention and a concept. So you can have. I'll go to. This is the definition: an exclusive right granted for an invention which is a product or process that provides a new way of doing something, or offers a new technical solution to a problem, and the right gives the inventor 20 years of monopoly on his new product. I think the idea is most people. Let me come to a quick explanation of this. If you invent something, there are a number of ways to protect it. If it is a new concept, a new way of doing something, a new product, or a process of manufacturing an existing product. What historically people did was, it's like they kept it as a secret, like a secret recipe, like a family recipe or something, and that will be protected under confidential information, which Ms. Chu will go through later. What you do when you do a patent is you reveal that process to the world by filing a patent, and in your patent you will describe how it works, and you will claim the monopoly of the product or the process. And in exchange for revealing it to the world, the state will give you a 20-year monopoly. So patent is, like copyright, a statutorily provided right. The state gives you the monopoly in return for revealing the technology, and there is a whole advantage to this whole process, because patents has actually caused the development of technology around the world, because you can then base any development from the existing patents, because you learn about it in that sense. So that's a very short understanding of it. And so you get this 20-year monopoly from the date of filing of the patent. Then the examples of, they're basically, it can be a process, for example, a gun bore cleaning system, spray chamber valve control system, method of operating a thermal valve system, door sanitation system. A product which is patented or in relation to a patented process, a product obtained directly by the means of the process to which the process has been applied. So you can have a patent of the product, like say there could be a special aspect of how this microphone works, and you could even have a patent of the process, say a special manufacturing process on how to manufacture this microphone if it is new. The next thing will be examples of patents as protection of ideas. You have the iPhone, that particular skateboard, the different these bicycles with different methods. These, when you see these diagrams with numbers, these are generally, the ones below would be how you would describe some of the inventions in the patent specification when you file it. Some fun facts. The most profitable patent ever belongs to the Pfizer, which Lipitor brought in 131 billion while the patent was still valid. I think Lipitor just went off patent very recently, which is why now the drug is, readily available in generic forms in as such. Then Google has granted the patent for a smart contact lens, which may allow diabetics to easily measure glucose levels. The individual tears will trickle through a tiny perforation lens to reach the sensors, enabling the blood sugar levels from the liquid. So these are, they are also very quirky. There are thousands and hundreds of thousands of patents which are filed and granted, but what we are actually using is a fraction of them. A lot of them are quirky things, like a portable bath capsule for administering bed baths and massages was patented in the US. The capsule was an elongated, flexible sheath of fluid, tight material enclosing the patient, except for the head, and having the means of emitting fluid and drawing fluid from the capsule. So this was patented because the examiner found that it's new, but it's not necessarily popular because the commercial success of something which is patented is not guaranteed. Then there's a shirt for a pet, where there's a shirt where you can put this gerbil, which is a kind of a sort of small rodent-like creature, where you can feed it in the passageways while you're carrying the pet around you. Then this is a ladies' underwear with a calendar that's also been patented. You'll be amazed at the things which have been granted. And then there's also this thing, animal ear protector, which developed in the 70s to protect the ears of long-eared dogs from coming in contact with the food while they drink. So it's something. It's very. You would think it's very conception, very simple, but the examiner found that it is inventive. It's novel and inventive. Then there's a hiccup treatment. A patent was granted in 2003 for a device that is made to zap hiccups away with a friendly shock of electricity. As the user drinks water, electrodes along the metal rod send an electric current to the nerve in an attempt to stop the hiccup. The thing to remember is there are three elements to get a patent. One, it has to be novel, which means that it has to be new as against the state of the art or what they call the prior. That means whatever is known throughout the world, not only in Malaysia, it has to be new. It has to be inventive, meaning that the new part of it cannot be obvious. And there's a third requirement of industrial applicability. It has to be able to be processed industrially. So all these were examined by the examiners in the relevant countries and found to have those elements. So the common misconceptions about patents. One, a PCT application gives me worldwide protection. For some of you all who are familiar with patents, there is something, you can file an application at the MIPO, which is a local application, or you can file something called a PCT application, either on the onset or after the Malaysian application is filed. So you've got that option. A lot of people get that confused with something what they call a worldwide patent. There is no such thing as a worldwide patent. The PCT application is merely a procedure for filing. It gives you the right to enter into a national phase for a grant in any country you choose. It gives you a 30-month time frame to decide whether you move to a local grant. The reason being is cost, because entering a patent into the various countries around the world can be a very expensive process. So previously, before we had the PCT, you filed the Malaysian patent. If you wanted to claim the novelty of the Malaysian patent, the priority date, as in the date when it was novel, when you filed it, you needed to enter into the various countries within 12 months. PCT gives you a 30-month period to decide. So if you are looking for funding or you're looking for investors, it gives you a longer time frame before for you to organize yourself in that sense. So it's a very useful tool for startups and investors and even even corporations. Once I file my patent, I have worldwide protection. No protection is territorial. You need to secure a grant of registration in every country you seek protection, which relates back to the whole issue of the PCT 30 months being helpful. Number 3, I can file my patent. I have successfully commercialized the invention. No, you may lose the right to file a patent for your invention, as the invention cannot be disclosed to the public prior to its first filing. There are some quirks on this. Malaysia recognizes the ability to file a patent 1 year after disclosure. However, if you choose to go abroad, you cannot do that because other countries don't, and you would have been considered to have disclosed the invention. So this is something, if you're only satisfied with a Malaysian patent, you can do it, but if not, it's a very dangerous thing to do. So you should quickly get your patent drafted and filed before you use it, before you use the product or disclose it. Number 4, I can sue once I file my patent. No, you can only sue when your patent is granted, but you can claim damages for infringement from the filing date of your patent. In fact, this is a very useful thing about the damages, because in the early days, there wasn't that right, and with some amendments a couple of years ago, we have that right. So you can give, if you know there's an infringement while your patent is pending, you can give a warning to that person and you can claim damages once your patent is granted. And finally, you can get a patent for software. No patent, software per se is not patentable in Malaysia unless it is combined with other features which in combination has a resulting technological effect, meaning that in your patent you cannot claim the code. That is protectable by copyright because that's something reduced to writing. You must, in your patent, specify a technical advance, a process of technical advance, how the software improves the function of something. So the people who draft the patents will know how to do that. In some countries, there's an absolute prohibition of software. Malaysia doesn't, but the registry does not grant it if it does not have this technical advance. And I think that is it for the moment. Yes, I think I'll give it to Kherk for the trade secrets.
Thanks, Gerald. So just a quick recap. So we have covered 4 types of IP rights now. First is copyright, then we touched on trademarks, then we went to industrial designs, and then we just covered patents, and moving to the last, what we call typical common protectable IP is confidential information. So let me touch on that. Confidential information. Generally, it is really information that is confidential to you and confidential to your company, like customers, suppliers, list of suppliers, the financial information of your company, business plans. All these are actually confidential to your company. Okay. So these are the examples that I've said. Of course, government secrets as well. Now, fun facts, just some quick one first. Best kept secret, 125 years, Coca-Cola. Who knows the formula of Coke? I think, and I don't know whether the Pepsi formula is disclosed or not, I'm not sure. But basically, the more famous secret is actually the formula for Coke. Another fun fact, sorry, this is the one that I was talking about. Another one, New York Times bestseller. Anybody knows how it's selected? No, it is kept as a secret. So New York Times actually will not reveal how they select a book to be a New York Times bestseller, and because they don't want publishers to play around the system to get their books up onto the list. In fact, they have a suit once by the author of Exorcist where his novel wasn't up in the list, and they sued New York Times, but they're not going to disclose how the list comes about. Yeah. Another fun fact, I think some of you are probably fans of KFC. Their recipe, just like the recipe for Coke, is kept as a trade secret. 70 years ago, hidden in a safe in Kentucky. Only a few employees know of it, and even then, when they travel, apparently they don't travel in the same together, so that the secret is kept. And once they were apparently modernizing their security systems, they actually had to transfer that handwritten recipe in an armored car to a secured location while they kind of like renovate and upgrade their security system in their plant. So much they do to keep it secret. Yeah. So misconception about confidential information. Some of you may be familiar with what we call non-disclosure agreements. Some may say that, okay, only a non-disclosure agreement can keep my information confidential. No. Confidential information is protected through what we call common law, in a common law manner, and through a contract. Let me explain the common law basis. Okay, if someone discloses confidential information to you in a circumstance that is understood that it should be kept as confidential, then the obligation starts. You don't even have it to be in writing. For example, I whisper to you and say that, hey, can you please keep this a secret? So and so and so and so did so and so and so and what and what and what, right? So the circumstance, if you replay in your head, the person actually told me that I have to keep it confidential. That is quite clear. Or you have commercial situations where you are looking for funding. You're disclosing your business plans to investors. Even if NDAs are not signed, okay, you can, whatever you disclose is likely to create an obligation of confidentiality on the part of the recipient, which are the investors. Because obviously, when you disclose it, it is understood that it should be kept confidential in the circumstance of that event. Okay, but of course, you don't leave to chances. You make sure that they sign the NDA as well. So don't fret too much if they don't sign your NDA, because there is still the common law protection. Okay. There is a registration process of confidential information? No. Yeah, there's no registration process. So there's only registration process for designs, for patents, for trademarks. Copyright, only voluntary registration system, but for confidential information, none. I can protect my invention and keep it a secret. This is a point that Gerald was making. You can't have your cake and eat it. If you want a patent protection, the requirement is that you disclose. In exchange for your disclosure, you get a monopoly for 20 years from filing. That is the exchange, and that's it. After 20 years, public domain. Or you keep it as a secret. Yeah. So we have a lot of clients coming to us. They want a patent, at the same time they don't want to disclose. So it's very typical. Can I not tell them everything? Can I keep back some parts of it? Answer is your patent may actually be invalid or may be invalidated later, because if you don't fully disclose, someone can't really work your patent, then it may be invalidated on grounds of insufficiency, we call it, or ambiguous. The claims are ambiguous, for example. So you can't have two. You either go for your patent or you keep it as confidential information. So you think back, you think about KFC, you think of Coca-Cola, the secret. If they have disclosed the process of making Coca-Cola, they would only have gotten 20 years of protection. But because they decided as a policy not to go for patent protection but keep it as confidential information, then they could. Now, usually what makes you decide which one to go for? I would say the question normally is, can you reverse engineer? Can you reverse engineer the Coke ingredients from a Coke? All of us drink Coke all the time, yeah? But can you reverse engineer and then to find out, okay, it actually has this component, and can you recreate the same Coke? Probably not, because they can probably make a decision that because it cannot be reverse engineered to the level, to the degree, therefore it may be more advantageous to keep it as a confidential information rather than as a patent, yeah? Confidential information has to be inventive or special? No, not really. It can be really very mundane things. Basically, your customer list, definitely, your business plans, definitely, your corporate information, which is normally not known, which is strategic, are all confidential information. Okay? Confidential information is different from trade secrets. It's actually the same thing. Yeah, some people use confidential information. Some people use trade secrets. Yeah, both does not have a special category. It's the same thing. All right. So we have now covered actually all 5 types of IP rights in probably just 30 minutes. So you now are experts on copyright. You're now experts on trademarks, industrial designs, patents, and confidential information. At least you have quite hopefully a clear understanding what each right is about. Now, life is not so simple because IP right doesn't come in so clear demarcation. Oh, okay, this is copyright. This is only IP. This product only has design. This product only has patents. No, most products comes in a bundle of rights. Let me show you. Look at that. Back to the Coke bottle. In one product, you can have all 5 IPs, right? The trademark would be Coca-Cola, yeah. Confidential information is what? We all know the secret formula of the ingredient. The shape of the bottle could be industrial design, yeah. Of course, you also have the stylization and words, which could be artistic work protected by copyright. That means your brand, if it's done in a very stylized way, you would have 2 protection. You would have trademark, and you also would have concurrently copyright protection over the artistic work. Who knows, the bottle cap also, the way it was probably initially made, must have been patented at once upon a time. Yeah, patent may have expired. So you can see that in any article, sometimes you have a lot of IP. Another one, so you can see all of us have a smartphone of sort. Shape would be protected. Yeah, you can look at your own smartphone. Shape can be protected by industrial design, unless it's very, very square and there's nothing special about it. Software, copyright. I'm sure inside they will have some mobile apps, which is all software, protected by copyright. Trade dress is actually also copyright sometimes, or trademark. The whole screenshot with all the icons. Some of them are protected by trademarks, and of course, because it's a design, a 2D design, is also copyright protected as well. Yeah, of course you can have a trademark, Apple or Samsung as case may be, and technology is probably protected by patent as well. So in one product, yeah, it can be really you have all 5 that we talked about. Okay. So questions now. I think open the questions to the floor. Any questions, anyone? If not, I may ask you questions. It's a test that you understood all 5.
Somebody tell you that you have infringed my design. What do you do? Or whatever my IP?
Industrial design?
Any of the IPs?
I think basically you will have to. Sorry, if you have been told that by someone that your product or whatever has infringed somebody else's design, I think you need to. Unless you can understand it yourself, to seek some professional help to assess whether that claim is that the person's claim stands to reason or not, depending on which right it falls within. So you need to do an analysis. But normally what would happen is that rarely is the case. If there's an infringement, what would normally happen is that you would receive a demand letter from the solicitors of the person who is affected, or a letter from them. So I think rarely it will be an issue if somebody talks to you in that sense. Yeah, yes.
I think due to time constraint, I understand. One last question, anyone? Okay.
Let's say we register our design.
We need to register our design to prevent other party from copying our design. But at the same time, we have not launched the product. So how do we protect the confidentiality at the same time? Because once we have registered, we have to submit the design. But at the same time, we don't want people to have a look at it because we haven't launched the product. So how do we protect this?
Typically, I think when you first file, your filing will not be open for examination by the public anyway. So you would be considered kept at the registry. So after you launch it, by the time, I think once it's registered, then that design may be available for search. But for a period, it will still be kept as, at least at the registry. I don't think the registry allows any party to actually examine pending designs which are not granted yet. Yeah. Okay. So, okay, with that, I think my host is telling me that I should rush it. I will end up with this tune which in every cartoon. Yeah. Thank you very much, and thank you to my panelists as well. Anyone has any more questions can come and see us immediately after this. The rest, I guess, you may have another session to go to. Thank you for your attention.